Welcome back from lunch. This morning we learned a great deal about public efforts to regulate artificial intelligence at the federal and state levels, but government never regulates alone, as we saw through Mona Sloan's superb presentation and Tino Cuellar's wonderful keynote. Private actors in the form of regulated parties and industry organizations, civil society, the market, or technology itself always play an important role in the reality of governance. And this is especially true in the context of evolving technologies, and even more so in the specific case of AI. Engineers in the private sector make the granular decisions regarding AI design. Private firms manage its deployment. Private stakeholders possess the information needed to understand the ways in which AI in the market affects different segments of our society. Expertise regarding so many aspects of AI resides not in the public sphere, but in private actors. And the nature of AI itself compounds the challenges of opacity and comprehension that always confounds government attempts at regulation. So what role does and might and should private ordering play in AI governance? How might we be intentional in constructing that role? What institutional, technological, and regulatory forms might best enlist the participation of private actors? And how might we ensure that decisions about AI and the way it in turn governs us reflects, on the one hand, private expertise and innovation, but on the other is not simply captured by a logic of individual private interest, that it also reflects public norms like transparency and participation, or fairness, equity, and efficacy. We'll learn about these things from our fantastic panelists. Christopher Yu is the Imisogi Professor in Law and Technology at the Penn Carey Law School of the University of Pennsylvania, where he's also Professor of Communication and of Computer and Information Science, and is the founding director of the Center for Technology, Innovation, and Competition. And Christopher, over his academic career, has demonstrated an uncanny ability to see around corners, to identify and engage with, before many others, critical issues in the governance of technology, from net neutrality to, today, artificial intelligence. He recently served as a member of the FCC's Broadband Deployment Advisory Committee, the Board of Advisors for the ALI's Project on Principles of Law for Data Privacy, and the Restatement Principles for a Data Economy. Nik Marda is the technical lead for AI governance at Mozilla, and he's also an adjunct lecturer at Northwestern University. Previously, Nik worked in the White House Office of Science and Technology Policy in the Biden-Harris administration, serving as Chief of Staff of the Tech Division and as a policy advisor in the National AI Initiative Office. There, he led policy planning, chaired the committee developing the U.S. government strategy on AI, and launched federal initiatives on privacy, digital assets, and civic tech. And Apolitical recently included him on a list of the world's top 100 AI leaders for 2025. David Evan Harris is a Chancellor's Public Scholar at UC Berkeley, where he teaches, among other things, AI ethics for leaders at the Haas School of Business. David came to Haas after 5 years at the platform formerly known as Facebook, where he managed teams of quantitative and qualitative researchers working on responsible AI, including AI fairness and inclusion, and AI governance and accountability. Before that, he served for 10 years as the research director at the Institute for the Future. Finally, Deirdre Mulligan is a professor in the School of Information at UC Berkeley, as we heard before. And at Berkeley, she's also the faculty director of BCLT, co-organizer of the Algorithmic Fairness and Opacity Working Group, affiliated faculty with the Center for Long-Term Cybersecurity, the AI Policy Hub, and the Citrus Policy Lab. She served as Principal Deputy U.S. Chief Technology Officer at the White House, OSTP, and Director of the National Artificial Intelligence Initiative Office in the Biden-Harris administration. And she's also past chair of the Board of Directors of CDT, the Center for Democracy and Technology, an initial board member of the Partnership on AI, founding member of the Standing Committee for the AI 100 Project, and a founding member of the GNI, the Global Network Initiative, the multi-stakeholder initiative to protect and advance freedom of expression and privacy in the ICT sector. So together, folks have such a deep well of experience in research, in government, in industry, and in civil society. Christopher will speak on standard setting as a tool of private AI governance. Nik will talk about open source AI models and public participation. David will present on multi-stakeholderism in AI governance, asking toothless or teething. And Deirdre will consider how to structure public approaches to AI governance to appropriately and best enlist private actors. And then I look forward to a robust conversation afterwards. Christopher.
Well, thank you, Ken, for such a generous introduction, and thank you to the friends who invited me here. It's a pleasure to be here, to reconnect with old friends and to make new ones. It's been a fantastic experience. And I feel particularly fortunate because the case I'm making, and that's not the first slide. We need to go backwards. There we are, thank you. I'm going to be talking about standards, and I feel like I should thank Brandy for endorsing this setting up, and some people setting up a conversation already talking about the role of standards here. And I'm going to actually lay out a case, and it's not just going to be an affirmative case. It'll be acknowledging some warts, because all cases have their limitations, and that's a big goal of what we're going to be doing. In two pieces of housekeeping or introduction, this article will be forthcoming in the Berkeley Technology Law Journal. Will be co-authored by fellow Alexander Mueller, who is here and joining us. And it is also part of a larger project on implementable AI standards that we are doing with Seoul National University, with Professor Yong Lim as my primary collaborator, who will be speaking on the next panel. So you'll get a chance to hear from him during the segment on international perspectives. So in laying this out, just to give you a basic structure of what I'm going to talk about, basically looking at standards and how they are, what they are, looking at the development process, and then really laying out a four-part case and limitations about why we would be thinking about standards as possibly or possibly not the best way or best modality for governing AI. And so we'll go through that fairly quickly. So what we see here is standards, to me, have emerged as the dominant means for regulating new technologies in ways that we used to really rely on governments before. And to me, I always think about how communication standards worked, because the ITU declared that it shall be certain ways, and all the telephone companies were owned by governments, and so therefore when they decided to do it, it all happened. And it was in a very centralized way. What we see now is a very different modality. And in doing this, we'll talk about the formations of standards on the next slide, but I'd like to distinguish between a couple different types. One is governance and management standards, and the others are technical standards. And what's striking to me is the process of what we're talking about now in the discourse is primarily the former. I heard people talking about best practices, and it's incontrovertible. Sorrell was saying that, I think, correctly. But the problem with that is that's only the management aspect. There's a bunch of technical dimensions, but to me, even in the management dimensions, the amount of validation, the specificity that we need to implement each of those best practices is still pretty underspecified. And as of right now, it's really in danger of sort of good faith, check the box sort of compliance, because people go, worry about bias. Oh, I did that. Well, without standards of knowing what biases and the standards you have to fulfill at that level, it's not going to mean very much. But I would say that in addition, there is a technical aspect to it that goes beyond that, and we'll talk a little bit more about that. There is an interesting question, too, that's sort of lurking behind this, which is, I think in a lot of discourse, and certainly in the current discourse, it's often thinking about a single AI standard that will govern all the domains. I would call it a research question, but motivated by deep skepticism. The idea that the AI standard to govern autonomous vehicles and healthcare and criminal law and employment is unlikely. What I learned from the IEEE standard here is that, in fact, autonomous vehicles aren't going to be a single AI standard. There's going to be multiple scenarios and different aspects. You see this in healthcare with different types of therapeutics, different types of diagnostics and the like. And there's an interesting question then is how much of the core is common where we would have similar principles governing all the domains, and at what point do we start separating out the domains? And there is a difference in the legal rule standards debate. That's not what we're talking about, but I'm not going to dwell on that here. Happy to deal with that in Q&A. So what would I say about standards? What's fascinating is there's a lot of definite dimensions we need to define them. So one is what's required and when it's required. The when is interesting. We've talked about this. I thought the unlearning case was presentation tutorial was helpful. There's the pre-processing, there's the model selection, there's the post-processing aspects, all of which have interventions of different things. But in addition, we have disclosure, validation, but ex-ante validation, but also in-market testing, all are going to play some role in ways that are not really determined yet. And what I love about that IEEE standard, even looking at just validation, they distinguish between design processes, formal methods, robustness analysis, simulation testing, closed course testing, open course testing. It's just to say validation leaves open a wide range of questions, because we all know there's a lot of things we do in the lab that when we put it loose in the world, we don't find the complex interactions until they go to scale. And then in addition, what we see here is the role of standards. We tend to, to my eyes, we tend to look at the harm AI can do, and we tend to be really focused on sort of the bad scenarios. And to me, that can be, we can think of this as for liability. In addition, there's a lot of auditing requirements, including under the AI Act. Unless you have a standard, there's nothing to audit against. And so, in fact, there's supporting this sort of information is very helpful. But what's interesting to me is beyond sort of preventing negative harms, there's an important role that standards play in value creation, which is if you're going to have a distributed system like the one that Catherine and Cooper described yesterday, you're going to actually have people interacting and contracting and trying to come to an agreement who's responsible for what. And if so, when you're going to provide them, when you give them a pre-trained model to someone downstream, they have to have some idea of what they're getting. And that could be ad hoc, or it could be standardized, in which case we're going to facilitate transactions. And there's a development of making it work in multi-party provision. Classic examples to me, this is how we do modular designs, object-oriented designs, all the things we know in software. Or what I love is coming out of open source, the difference between the cathedral and the bazaar. And the question is, you have to have principles that organize the bazaar. There is a standard development process. They differ in geographic scope, they differ in composition, but they also differ in membership rules, voting rules, in ways that are absolutely critical and outcome determinative. And so we can't just talk about SDOs in general. There's different flavors of SDOs. And we need to develop some analytical science about what's well constructed. Here's a bunch of initiatives at different levels. You can get this off the slides. That's just informative and historical. Okay, so the case for it, I would say that my goal in running quickly through the case, I want to look at both strengths and weaknesses. And I do want to think of this as a comparative second best analysis. Often posited in terms against regulation. Standards, I think, have some strengths, but we shouldn't pretend that, just because regulations got problems, the opposite is nirvana. And so we have to actually look at the best iteration of standards versus the best innovation of regulation and understand where the shortcomings are and decide which of the second best outcomes is preferable. And that's sort of the standard way we analyze things now. And I'm going to look at 4 things, looking at the decentralized nature, expertise, agility, and coordination. All right. Decentralization, this is really an alternative to classic command and control regulation where people vote with their feet. And in fact, what you see is, I always think of, if you look at textbooks, people said Wi-Fi was going to be this little niche technology and Bluetooth was going to be the primary way we connected things locally. Well, needless to say, it's probably the opposite. And in fact, that's not because anyone decided that, it's because the community decided it. These technologies were put out there, people voluntarily adopted, and in this way we can unleash market dynamics, bottom-up decision-making, decentralized decision-making in ways that can often lead better technological outcomes. There is a literature looking at government set standards that's not very complementary, that suggests that they get politicized or are not very good at digesting technical expertise. But what you also see is parallel efforts by different SDOs experimenting with different solutions. And what I really see is a two-part phase, which is at this point, there are a bunch of organizations vying and competing to be the AI standard setting organization. And at this moment, there is real choice and real competition. There is a stage after this where once the standard is chosen, it can get quite locked in. But the nice thing is there's a way we can do this, which is actually there's decent proxies for consumer interests and industry interests, because if you're not creating a good standard, you're not going to get adopted. So if we can actually surface things during this competitive stage, and then once it's adopted, we can actually make them live up to the promises they made that led to its adoption. And in this sense, the government's role comes a little bit different. It becomes enforcing the promises that were made before, which is something it tends to be better at than picking the best technology because of their decisions. And in fact, it allows things to change. What I would say is, there is a real problem of market failure and even capture of these agencies based on how we constructed them. And we need governance because no solution is going to be complete. We're going to have to go this before, and we do worry about really a race to the bottom and a trade-off between what you're going to do to get adopted and whether you're doing the best standard. There is more expertise. It's funny to hear this because agencies are often sold because of their expertise, but it's a different type, it's a different composition. The way I always think of this is why we like commercial arbitration. You get experts in the field instead of judges who bring a different insight into what's going. The hope is the same. The cutting edge they know about, ongoing developments they know about better, and that in fact you can construct a SDO process to be multi-stakeholder and to get inputs from appropriate people. And to me it includes rivalry. One of the ways we harness this and we guard against capture is we get different parts of the industry fighting against each other. In most tech problems I know, there's tech on both sides. And there's different interests on both sides. And we can use that in sort of separation of powers of dividing a house against itself to actually try to get protection through it. There are a bunch of problems. I mean, to participate in SDOs, you need a certain amount of money. I would say new technologies often get underrepresented because they don't have revenue. And in fact, there's a potential, again, for problems of legitimacy. Agility, there's an information lag in regulation, as we know. There's procedural friction, which my pain to Paul, he says friction is a virtue, not a vice. And I would say is that, in fact, both SDOs and agencies are accused of being ossified. And so we can't just say, oh, one's more nimble than the others. They're going to have different aspects to them, and they play out in different ways. And the problem is some of the ossification is participation of public matters. And so it's feature, not bug, and finding that balance to make that go can be quite tricky. And then lastly, standards help things scale, coordinate, reduces compliance costs, all the things that we know about making this better. But for there to be a standard, there has to be an underlying degree of homogeneity. And in fact, if there's too much heterogeneity in what people want, they're not going to work on a single standard. Geographic rivalry is a huge issue, and there's a problem with the subversion of public authority. That said, as Paul was mentioning in his point, we can harmonize, and we can do things that work better. We can do uniform laws, a lot of different aspects. So I don't mean to overstate it. We have to think about really what the potential is. Last slide. So we need to have a debate. What is it? What's the role of standards? Is it the right thing? But also, even if we think so, or if we're trying to decide whether to do so, we have to think about how to structure them in terms of what their technical components are, how we're going to have participation, voting, ongoing monitoring, and to protect against rivalry. One of the most interesting things to me also is the timing of standards adoption. There's something in the literature that says you shouldn't standardize too soon. Dominant design literature, modularity theory all suggest that there's such a thing as too soon. And that explains to me why a lot of the stuff we see now is process-oriented, because we really don't know how to write those technical standards at this point. And so the question is figuring out how to do that right. Speed and legitimacy, and then really the issue to me is we have to be aware is there are compliance costs. And what's interesting in the project that I'm doing with Yong, we've heard some fascinating things. So I've been told that, for example, the first use of AI by the federal government was handwriting recognition by the postal system. The negative stakes are fairly low compared to other venues. They're not zero, they're never gonna be zero. But we, in the conference that we co-organized in January, Nicholas and Price gave this example that there is a stroke medication that if someone's hooked up to a machine, that is incredibly beneficial if administered immediately, but has very, very few negative consequences if the AI is wrong and it's administered in error. And so what we can start to see in playing these things out, we have to think about the risk-benefit analysis. And in this case, maybe the AI was wrong in the medical case, but if it's life-saving and you need that kind of responsiveness, he's saying that's a case where we may take the human out of the loop in the nature of the goals we're trying to preserve, but that's going to vary context to context in ways that I think we need to think our way through this process. Thank you very much.
Hi, folks. Is this working? It will. Testing.
There you go.
There we go. So hi, folks. I'm Nik Marda. It's wonderful to be here and to be on this panel and with you all today. I'm going to talk about the role of open source in advancing AI governance. And I'm going to give a lot of caveats at the start to tell you what I'm not going to talk about, because otherwise this could be like 2 hours long if we're going to actually talk about open source, AI, and governance. So a couple things. Let me just tell you first what I mean by open source AI, because that's been a big debate that I know many of you here have been a part of. I'm going to use the term open source AI a bit loosely and broadly and not specifically. And I'm going to use it to refer to AI systems where components can be freely used, studied, modified, and shared. And we're not going to get too specific about what we're talking about there. We're just saying broadly AI systems that are more open. I'm also going to avoid talking about the governance of open source AI. So the last 2-ish years, there's been a big debate about whether AI systems should be more open or more closed, and there's been a debate over whether the benefits of increased scrutiny and greater adoption of AI outweigh the risks of making cutting-edge AI capabilities more accessible to the general public. And that's a really important debate, and we're going to not talk about that here. Instead, what I'm going to focus on is how open source AI can help make AI governance as a practice better. So how companies are using open source AI as a way to help make their AI systems safer, how that's changing some of the practices around AI governance. And it's a pretty broad topic, so I'm going to give you 3-ish specific examples as we go through here to try to show you the ways this is playing out in practice. So to get to that, I want to start by giving you a frame for how, at least I'm at Mozilla, and a lot of what we're thinking about is how do you bring in more communities into the development of AI systems? So a broader sort of theory of the case that having more communities and diverse participants in the design and testing of AI systems will help make AI systems safer and more beneficial to everyone. So the word that we've been indexing on, and that a lot of the people we work with are indexing on, is this idea of pluralism. And it's this idea that having diverse and competing views and communities coexisting in practice with each other, that you don't have to have one right answer for what AI safety is or what good AI is okay. And in fact, in this particular moment where many of us might disagree with what might happen at the federal level on AI safety and AI governance, it's helpful to have many perspectives able to coexist with each other. So why does this idea of pluralism actually matter? And I want to start there by focusing on AI safety as this concept, right? It's not a well-defined term. You've heard through panels throughout today that we don't really know, for example, exactly what great AI governance looks like, or that we're in the early days of AI regulation. And so if you start with the premise that we're going to keep figuring this out over time, and that there might be many different answers at play, the idea here is that a pluralistic approach to AI governance means that you can have multiple different ideas of AI safety in play with each other. They can all sort of coexist. And that makes sense in a lot of contexts too, where in different cultures or communities or applications, you need different approaches to AI safety. Some of what Christopher was just saying, for example, right? There are some use cases where you would think about AI safety very differently than in other use cases. And so the idea here is that we can expand the notion of AI safety and bring more communities into AI safety by promoting pluralism through open source AI. The idea basically is that instead of having a couple of large tech companies decide what AI safety is, which I would argue is sort of what's happened over the last 2 years, you can have more people engaged in both building and developing AI systems, but also articulating what are the values we want to embed in here. And you can have individual developers and small nonprofits fine-tuning AI models and building on top of AI systems with different safety principles. So one particularly interesting example here that I think will help sort of clarify this more abstract point is actually from DeepSeek from a couple weeks ago. So DeepSeek released R1, right? This model that came out of a Chinese company that had a bunch of censorship in it in a way that prevented you from asking questions about particularly politically sensitive things in China. And that model is being used around the world, right? It's created this whole conversation about whether this is a good or bad thing. There's sort of an argument on one side that this is very performant and it's a very good AI model. On the other side, it's what are the values we're embedding and what are the risks of building on top of this system writ large. But the interesting thing is that the American company Perplexity fine-tuned a version of this model, which they had released as a more open model. It was open weight. And they released a model that they called R1 1776. And the idea there was they fine-tuned out all of this censorship and created a model that would give, in their words, unbiased, factual information. And this is interesting, right? Because you can now imagine American AI companies choosing to use R1 1776 as the base model for their development, while Chinese AI companies might just use R1. And both of these models can exist side by side, and we all can have opinions on whether it's good that R1 exists in the world and is the basis of some innovation. But I think it is personally better for the world that we have this fine-tuned version that can be the basis, rather than just having to build on top of R1 or having a bunch of private AI developers build on top of R1. So this is one of those examples of where the fact that they released it as an open weight model gives us the opportunity to fine-tune a different version of safety on top of it. So there's one example. Another example I want to give to why open source approaches to AI are important is that it helps bring underserved communities into the work. And the example I'll give here that I think gets to it, and this is not just about AI models, I'm talking about sort of openness across the stack, so this is more of a data example. But if you have an iPhone and you go into your settings for your iPhone and you click on Siri and you try to change the language that Siri works in, you'll get a couple dozen options, but the only African language you'll find in there is English parentheses South African. There isn't a native African language in Siri. And that is kind of crazy when you think about the fact that there are so many different native languages around the world where their speakers only primarily speak that one language, and we are not building AI tools that work for them. So there's a digital divide question there, of course, but the point I want to get at here is actually that this matters for AI governance as well. So many of you here probably know the example of how when Facebook was introduced in Myanmar and was used in Myanmar, there were only a couple of content moderators in Facebook that actually spoke Burmese. And this mattered because a lot of the translation they were doing was basically they would attempt in some cases to take Burmese, translate it to English, and content moderate. Or they would just not really do content moderation at all. And that meant that content moderation wasn't happening at the level it needed to happen in Myanmar, a country where they had something around 18 million users. And there's been a lot of sort of scholarship and literature about how Facebook contributed to a genocide in Myanmar, in part because they weren't moderating content in Burmese. And this matters because now, in the context of AI, you have AI models being used increasingly for content moderation on a lot of social media platforms. But if we're not building AI systems that work in other languages, or we're using sort of retrofitted approaches to translate from one language into English and then moderate, the quality of that moderation is worse, and it has real implications for how AI is safely used around the world. And so here's where the open source bit comes in. there aren't strong commercial incentives to build AI models in a lot of these languages that are only used by a couple million people around the world, even though it really matters to those people. And so one of the projects we have at Mozilla is called Common Voice, and it's this platform. It's an open source platform where folks can donate their own voice in their native language, and it gets added to this platform where AI developers can download data sets in different languages and train their models on top of those languages. And the thing here that's interesting is that a lot of companies don't have the financial incentives to do this for their particular use case, but an open source project like this can build those databases and essentially reduce the friction and the cost for companies to build AI models that work in different languages. So there's this element of trying to fill gaps in the AI ecosystem that a combination of open source approaches plus philanthropic funding and proper resourcing more broadly can really help make AI more safe and more effective. The last bit that I want to give as an example is around open sourcing safety tooling. So the point I want to get at here is that a lot of companies actually do want to do the right thing with the huge asterisk of it needs to just not cost too much, right? Like if you get to just choose in the abstract between releasing a safer AI model and a less safe AI model, and there's no other trade-off at play there, you're going to choose the safer AI model, right? But in practice, there are a whole bunch of obstacles to making an AI model safer. And so you end up with shortcuts, you end up with a lower standard. And that is in part a friction problem, right? The friction to making AI safer in practice can be real. And so we at Mozilla have sometimes called this a digital safety divide. The idea that access to some of the tooling and expertise and resources to make AI safer is not evenly distributed. And so one very specific example in this subset is the work needed to remove child sexual abuse material from AI platforms and data sets, right? This is a thing that no AI developer wants in their AI product, but in practice, the tools to actually identify and remove CSAM from AI training and from AI models are actually kind of hard to use. If you talk to anyone who works in this space, you'll hear about all of the very specific challenges about using Microsoft or Google's tools for this. They're not well maintained. You can't really get great customer support when you need it in using these tools, and it creates a real problem. And the other tools in this space are either proprietary or they're really expensive. And the ones that are open source are also not super well maintained. And so you have this ecosystem of safety tooling that's just not up to par for what's needed for, say, 3 engineers tinkering in a WeWork across the bay somewhere in SF, right? What are they going to do when they're building their AI system and trying to get their first customers? They're probably not going to want to put in that much effort to mitigate various risks, even the ones that are kind of serious like this one. And so part of the work that can happen is to make it easier for them to mitigate those risks. And so there's a specific initiative that launched earlier this month called ROOST, the Robust Open Online Safety Tools, which is an acronym I love. And this is a nonprofit consortium that's building open source tools for AI safety. It's backed by more than $25 million and partnerships with a lot of the key players in this space. And they're starting with the focus on making child safety tools more plug and play. So making it easier to access the various systems you need to access to find and mitigate CSAM content, while also creating new tools for AI developers and better sort of benchmarks and governance approaches. And so that type of work, I think, is really important because you're essentially expanding access to the tools that are needed for AI safety. And in the process of doing that, there are all these second-order effects, too, of increasing public expertise on AI safety, of increasing public knowledge about these issues, about bringing more people into this work more broadly, which has all of these second-order effects on AI safety writ large. So I want to wrap and sort of bring these 3 examples back together and contextualize why it particularly matters in this moment. I think you've heard, especially from the first 2 panels today, that we're in this moment where AI governance feels a little tenuous, right? It feels like, and I certainly feel this way, that as it comes to federal policy especially, but also policy more broadly around AI, we're in this moment where it's a little hard to imagine significant, meaningful policy to help make AI safer that can apply sort of across large jurisdictions. And I see open source approaches to AI as an opportunity to help move the ball forward on a lot of important AI governance issues in practice within companies, in the AI ecosystem, with how technologists are building AI, while that work sort of on policy continues and we all try to make that happen. And it gets to this point, I think, largely sort of what Christopher is talking about in terms of sort of a more bottom-up governance approach and a standards approach, where we have institutions like NIST and the AI Safety Institute that you heard about earlier, sort of potentially being gutted in the near future. Those institutions exist to try to take a lot of the best practices that are emerging across industry and create sort of a floor for what everyone else should do, right? So you find a company over here that's doing something really great, and you find another company that's doing something similar, and you try to articulate, like, here's the least common denominator of those things that we think would be good. And you're trying to advance guidance in that way. And open source at least creates an opportunity for that to happen more organically while some of these institutions are being gutted. So you can imagine more companies making their AI safety practices and their AI models more open, and that helping to create that floor and for best practices to emerge sort of more cleanly and more organically in the process. So it's certainly not a replacement for what's happening and what needs to happen, but it is an important opportunity that I think is even more important now than it was even just a few months ago. So with that, I will wrap.
Thank you so much for having me. I've got some slides, hopefully. Okay, there we go. Okay, I'm David Harris with the Haas School of Business. I'm really excited to be here with all of you. As was mentioned before, I did work at the platform formerly known as Facebook. I worked at Facebook and Meta from 2018 to 2023, but I did teach here at Berkeley the whole time. I did that because I wanted to have a window into a different world outside of the bubble of a big tech company. And so this is my 11th year teaching on campus. So one of the things that struck me while I was at Facebook, I worked on the civic integrity team, working on election issues and trying to stop election interference around the world. I worked on the social impact team, and the last team I worked on was the responsible AI team. And I got a lot of chances to engage with people at other companies. And during my time in Silicon Valley, I learned about something called the metaphor of the bear. And I would love to know, after I share what the metaphor of the bear is, if anyone else has heard about this. I know that at least two of the companies whose logos are featured in this image use this as a management strategy technique. And the way the metaphor of the bear goes is the regulator is a big bear. And all of the tech companies are people being chased by that bear. But the bear is only hungry enough to eat just one of them. And so when the bear starts chowing down, the others look back and they realize, if they're way far ahead, they realize, I expended too much energy, I ran too fast. And so the way this metaphor is used is to make the point that the optimal way to maximize profit, if you are a tech company, is to be the second slowest. Be the company that almost got eaten by the bear, but didn't. That's where the money is. And the fact that this is an explicit management strategy in these companies made me, along with a lot of other things that I saw, come to this realization that the thing I really wanted to do with my life at the beginning of 2023 was work on helping pass binding and enforceable AI regulation, because I don't think the tech companies will do it on their own. So I do this through a handful of different hats. I work, and these are all places that pay me. This is my disclosures here. The Brennan Center for Justice at NYU Law School. I work with them on AI and elections. Cited, the California Initiative for Technology and Democracy. doing a lot of work in Sacramento with them. I'll talk a little bit more about that. ICSI, International Computer Science Institute here at Berkeley, and the Center for International Governance Innovation in Canada. So I kind of put together this portfolio of nonprofits that I advise or have fellowships with that's allowed me to engage in a lot of these multi-stakeholder initiatives. So here are my key points. And I speak today, someone used the term earlier, under-theorized. I speak today as a practitioner and as a non-lawyer. And so I apologize if I give rough versions of any of the concepts and thoughts here. But today, what I've observed, participating in many different multi-stakeholder processes, mostly as a civil society member or an academic, is that it gives the companies a really significant advantage. And this manifests in so many ways. The obvious one is they're better staffed, but that better staffing doesn't just mean more people. They often have global offices, so they can go to lots of different venues much more easily. And then they have the four, and sometimes there's a fifth, but NetChoice, TechNet, BSA, CCIA. These are these industry associations that allow the companies to hide behind them, so their name isn't out there, but then oppose all kinds of different pieces of legislation or elements of different standards. And that also allows them to span many overlapping jurisdictions. They can participate in so many different things, and they have better access than NGOs. Great book from Marie Chishaka at Stanford called The Tech Coup. She talks about how Microsoft would often have a seat at a table where everyone else in the room was a government. And that's a really important phenomenon for us to realize that access is inequitable in many of these fora. Also, the fact that there's so much overlap between these fora is very confusing for even the larger NGOs. The fact that there's both an EU AI Act and a Council of Europe AI treaty is very confusing to a lot of different people. You need to do a little bit of homework to figure out that the EU and the Council of Europe are two totally different bodies, and the two things have nothing to do with each other, and that the US can be part of a Council of Europe treaty. So anyway, there's also, with a lot of these initiatives, most of the time, there's very little chance of creating binding or enforceable laws. And I think they can also have the even worse effect that they can be not only unenforceable, but delay enforceable regulation because there's something that you can point to and say they exist. I think also they often appear to only serve as PR opportunities. So I'm going to zip through some examples. I wanted to define multi-stakeholderism, a model of governance involving states, private sector, and civil society. Not always all three, but at least two. And then governance, we're talking about governance regulations and also standards here. And then when I say civil society, I'm including not just NGOs or nonprofits, but also academia and journalists. I think they have an important role to play. And I think one of the phenomena that's so important to understand, especially at this moment with AI, is this idea of tech exceptionalism, which is repeated so often in these fora. And it's this school of thought that, as technology is this new sector, it should not be subjected to existing rules of business and norms, and maybe it just shouldn't have any laws at all. I, of course, disagree with that. So transparency washing is a really important term, I think, to think about in this, where a lot of the goals of these multi-stakeholder initiatives end up being about transparency. Now, transparency is all well and good, except when it is also a substitute for something that actually causes a company to cause less harm. I like this definition here. It's a way of diverting the attention to procedural micro issues that have little chance of changing the political or legal status quo. So I'm going to show you, so this is the beginning of a chart. This is a work in progress of all the different multi-stakeholder initiatives on AI governance. Now, as my colleague discussed earlier, this is maybe a moment where it's good. There's competition for developing different standards, but I do think it's possible to have too much of this as well. And the reason why is because it stretches the already overstretched civil society organizations that are attempting to speak up for people and the public interest really, really far. So there are a bunch of them. My first section here is private sector and civil society-led ones, and the second section is public sector. And I also public sector-led, which often have all three. And they also work on a bunch of different overlapping issues. So give you a quick overview of some of the private and civil society-led ones. The AI Elections Accord is one that I recently published an article on with the Brennan Center for Justice. This was signed a year ago at the Munich Security Conference. And 27 companies pledged that they were going to do a whole bunch of things, 8 different things to protect elections from AI. Most of them either didn't do it, partially did it, or kind of sort of did stuff but didn't give any evidence that anyone could use to verify if they did anything. It was very, very disappointing. And there were a lot of the organizations, the companies that just simply didn't respond at all when asked. We sent emails to them. Senator Mark Warner's office sent emails to them asking them for information. They had a website where they could report. But it was very, very disappointing. One of their pledges in particular that they did not follow was a pledge to engage civil society and academics in the process of fulfilling this accord. There were no concerted efforts whatsoever to bring civil society or academics into a conversation with all of the signatories. It was, yeah, disappointing. Another one that I think was a great initiative by 2 organizations that I really like, Thorn and All Tech is Human, is the Safety by Design Principles for Generative AI. And they got a bunch of companies to sign on to them, a few of which are just flagrantly violating this stuff and continuing to host AI models, as was discussed earlier by Nik, that are trained on child sexual abuse material. Either host them or produce them or not use the trademark or other intellectual property resources at their disposal to try to recall these models. And so this is, again, a case of civil society expending a lot of effort to bring a lot of groups to the table and not getting results from some of the key violating actors. There is something that's maybe interesting here. The Australian E-Safety Commissioner's Office has some new rules that might actually allow them to do something about those types of models in particular. And maybe this documents some prior knowledge of the fact that this was a problem. They were advised of it in public. Now I'm going to zip through a bunch of others just to give you a sense of what the field looks like. There's the Coalition for Content Provenance and Authenticity that is creating standards about watermarking, provenance, AI disclosure. There's Meta as an individual company has these community forums on AI with the help of Jim Fishkin at Stanford, who does participatory democracy. Meta also has an oversight board separately. There's the Partnership on AI, which is both an organization and a series of multi-stakeholder engagements. There's the Frontier Model Forum, which is the group of mostly the larger AI companies that are doing cutting-edge models that are releasing statements as well. ML Commons, sorry, it's missing an S, also an organization, but a forum that got its start on hardware benchmarking in AI, software tools to standardize that, but it's moved into AI safety. Future of Privacy Forum, which just had some unfortunate news that they had to step back from a lot of their AI work. The Internet Engineering Task Force working on robots TXT and opt-outs for rights holders. International Association of Privacy Professionals working on governance and auditing certificates. So the Christchurch call, thinking about governance of ranking and recommendation systems in social media that might allow terrorists to broadcast information and how to combat that. So there's a lot. There's a lot out there. Just to try to follow all those things is a lot, and I'm sure I missed some, and I hope you'll come up to me after and tell me which ones I missed. And then there are the public sector initiatives. So Deirdre and Nik were involved in this one, the AI voluntary commitments from the White House. And this was one where the conditions were not ripe for the White House to actually follow up on this because of the complaints about jawboning and attacks from the United States Congress on the administration. I thought this was really well written and really exciting, and that the companies who signed it mostly didn't follow up. In fact, there was, as far as I can find, almost no comments by any of the companies that signed this even claiming to have followed any of these things. Very disappointing, and not your fault. You were in a difficult situation. The National AI Advisory Committee, created by Department of Commerce through NIST, great body, great people that make it up. Unclear to me the pathway that leads it to binding things. The ISO IEC JTC1 SC42, I just tried to ask the library to get me a copy of the standards, and and the library at Berkeley won't even pay for them because they're so expensive. And the idea of standards that you can't get as a student or a faculty member at UC Berkeley, I mean, that was enough to turn me off. But I went to Geneva and tried to hunt down the guy who was in charge of the AI one, and he didn't even respond to my LinkedIn messages or emails. So AI Safety Institute Consortium, I'm a member of this one. This is fun because sometimes I get to interact with people in the tech companies who will actually do follow-up meetings with me. It can be substantive. It allows me to have interesting conversations. Again, no clear path to anything binding. United Nations high-level advisory body on AI. I've also engaged with this one. Amandeep Gill is a great guy. He invited me to one of their sessions. We talked a little bit, really unclear how this gets to anything binding. G7 Hiroshima process, again, I went to a meeting of theirs in Paris a couple weeks ago. Really sounds exciting, except it's not binding or enforceable in any way that I can figure out. Maybe it's something that people point to in the future in some way. Now, this is where it gets exciting. Sensenelec, JTC 21, artificial intelligence. This is the European standards body that is probably going to be charged by the EU AI office to create a standard that is enforceable under the AI Act. And so I've spent some time in a related thing I'll get to in a second. There's also the EU AI Pact, which I think is a really fun pun on the EU AI Act. And this is like a early admission to the EU AI Act. If you want to voluntarily comply before you're required to, you can sign up and get in this excellent photo opportunity in Brussels. And then the Frontier AI Safety Commitments, this was the Seoul Summit. I think a lot of people forgot about this one, but a bunch of companies signed onto a thing that said they would do something after the Seoul thing. And maybe some of them have reported on it, but I'm really not sure if they've published anything. Last I checked, they hadn't. Council of Europe AI Treaty. Now this could be binding, could be interesting, except the whole private sector is exempt from it. It only applies to government use of AI. Disappointing, but still maybe we should ratify it. And EU Digital Services Act doesn't say AI in the name, but it regulates algorithmic systems. This is a really exciting one. They do lots of multi-stakeholder engagement. I will definitely spend my time on this. The EU AI Act Code of Practice Working Groups, I'm a member of this one. Definitely worth the time, except there are claims that it will be butchered soon when it gets to Sensenelec. And then California. I actually think California is a great place for all of you to engage. So I testified 11 times in the California legislature last year. And they are hungry for people who know things about AI policy. There are lots of legislators in California who can pass real laws and have no experts to talk to about these things. It's just in Sacramento. So to wrap up here, multi-stakeholderism gives AI companies major advantage. Most of the initiatives have little or no chance of enforceability. The voluntary efforts can delay real laws. It often appears to only serve as PR. Civil society can just be window dressing in many cases. Sacramento needs expertise. Lots of bills are flying. As a civil society actor myself, if given the choice, I can't really justify participating with my limited time in voluntary efforts with no path to enforcement. So in conclusion, it's mostly toothless. There's some teething in Sacramento and in the EU, and demand enforcement, and don't forget the metaphor of the bear.
Thank you for that whirlwind tour, David, and for testifying 11 times. All right. Thank you all for I think there's been a lot covered already today, not just on this panel that I'm going to touch on. Hopefully, the big green one, yeah?
Do we have slides up?
Okay.
Okay, no problem. Thank you so much.
Well, I will just start. This is work with Ken, one of my favorite collaborators. I also have some work with Nik going on right now, who's also one of my favorite collaborators, and specifically on new governance for artificial intelligence. Let's see, no, still not working. I will tell you what my slides say. So a lot of the conversations around AI regulation, there are two big debates: rights versus risk-based regulation. We heard some of that yesterday in our tutorials, a little bit earlier today. Another massive debate, new versus existing institutions. Do we want to stand up a new separate AI regulatory agency? Do we want to empower our existing regulatory agencies with new authorities? I'm going to talk about those. I'm then going to talk about why Ken and I want to argue that the right way to think about this is as a new governance approach in what we see emerging. And I'm going to talk a little bit about what that looks like in practice with some case studies. So the major debates in AI governance. We have the rights versus risks debate, right? And Margot talked a bit about this on Thursday. It came up a little bit earlier today as well. This idea that risk-based regulation or a risk-based approach is more in a product liability mode. It doesn't tend to focus on individual rights. It doesn't afford individuals individual remedies. In contrast, our rights-based approaches, which are, our civil rights laws, the GDPR in Europe, other things that are very specific about individuals, seeking to protect individuals, affording them with recourse to courts, and other ways in which they can perfect the rights that they have been afforded, and with companies, governments responsible for protecting those interests, right? Very different frameworks. So that's one debate. I'm a little off kilter here. The second is this new versus existing institutions. We had many AI industry leaders up on the Hill participating in the Schumer roundtables, testifying, basically saying, please, please regulate me. Please create a new institution for like the 3 or 4 companies, maybe so that we could totally occupy and own it. I don't know. Just saying. But right, a lot of conversation about whether or not we wanted to create a new institution that was bespoke to AI to do the regulation. Now, one could think that we need new tools and methods to approach AI. I've been around in tech policy for quite some time, and some of you may remember the debates after General Poindexter's total information awareness. Do you remember that system? Where I was dealing with many legislators on the Hill who wanted to ban data mining. Come on. Some of the I was like, what kind of math would you like us to stop doing? Right, was the question. And what I want to say, there's a little bit of techno-fetishism in the idea that what we're going to focus on is a whole new regulatory apparatus for AI, right? And if anything, the turn that we're trying to take is to say that AI, like every other mathy tool that we use, has to be regulated in a way that is domain-specific. Right? We have very different ways in which we approach thinking about whether or not a tool is appropriate in a given domain, and setting up a whole separate regulatory silo for AI might create some like battle of the agencies, might undercut existing agencies that have real enforcement authority and can provide real remedies, right? So I think thinking about this conversation, it's really important to take a little bit of a realpolitik. Like, all we hear ever is, please don't be overly prescriptive about technology, except we'd like you to create a whole new agency to regulate just AI. Hopefully that makes you giggle. It makes me giggle. Okay. So I've given you a little bit about like what I think some of these debates get wrong. So I want to start, the one is like the misconception about the regulatory frameworks. I do not think that the AI Act in Europe, nor the efforts in the US, including the AI Risk Management Framework, standing up the AI Safety Institute, are in competition with the existing rights-based frameworks. Right? What they are designed to do is recognize that when we're talking about technologies that operate at a statistical level, we actually want to be doing systemic reviews of them, not just relying on individuals as the sole means of protecting the mass harms that they can create, right? So this is a layered approach, and they are layered and complementary. Second, this has to be a whole of government approach. The AI executive order, it basically directed every agency in the US government to do something. And that's because we view AI as being a pretty transformative technology that is going to touch people's healthcare, it's going to touch people's finances, it's going to touch national security. It's going to touch every aspect of the ways in which we interact with government and interact with other key organizations during our daily lives. And so we need those institutions to be scaled up. We need them to be thinking about how AI is changing the ways in which they enforce the laws, whether they need new new regulations underneath their existing laws. We had the key enforcement, civil rights enforcement agencies during the Biden-Harris administration stand up and say, hey, AI is not some like law-free zone, right? Like all of our existing rules apply to you. To the extent that we need new frameworks, they are frameworks that will help us do this like proactive, one could almost take precautionary sort of analysis, right, to these systems so that we don't have to rely exclusively on you individuals figuring out what went wrong and trying to get into court where perhaps the harms that you've experienced might not be one that's viewed as justicable, right? So we need new and old institutions. The final thing I want to talk about is the importance of stakeholder engagement. And I appreciate both Chris's presentation, which I think tried to help us tease apart different kinds of multi-stakeholder, quote unquote, standards in that very big umbrella framework, distinguishing between things that are technical standards, measurement standards, and things that are management standards, right? And it is important, and I think when we're thinking about AI governance, we need to be concerned about both of those. And importantly, for too long in this country, we have delegated the technical standard setting almost exclusively to the private sector when it comes to things like what sort of technical mechanism should we have for privacy or for security? And having the civil society, the academia, right, and the public entities in the room when we're having those conversations about the technical desiderata that is going to be important to addressing systemic risks and protecting proactively on the front end individual rights is an important development, even if it's teething. So the new governance approach, I think many people in this room are well aware of the idea of new governance. It steers away from the idea that kind of governance happens from the top in some one-directional way and tries to use the government as a way to enact a more multi-stakeholder ecosystem of enforcement. And so key questions when we take a new governance approach is who has the expertise, who has the competency, who has the right kinds of legitimacy, right? Either both they have the right kind of independence, they have the right kind of relationship to affected communities. Yeah, and so we need to be thinking about all of these things as we construct our regulatory approaches. And that requires us to think about engaging the right stakeholders and how we engage them and where we engage them. And this gets us to that point of integrating these new and existing institutions. So if we're taking this rights-based and risk-based approach, certainly one key element is leading with public values. And as I said, the work that the Biden-Harris administration did on AI started with the AI Bill of Rights. I'm leaving off the blueprint because I can. I'm no longer at the White House. It's an inside joke. And what it was so important, right? It was the lodestar. It was like the way in which we're going to be approaching AI is going to be guided by these core values. And I believe that Sorrell did a lovely job of saying, these are not new things, right? Privacy, due process protections, making sure systems work when we unleash them on the public. You're like, this is not rocket science, nor is it all that new. Thank you. Many privacy experts, I think, were downright furious because they're like, we've been doing this stuff all along. What do you need this new thing for, right? But why we needed it was we needed to be clear that the entire approach was centered around the public's rights and safety. But identifying the rights that are to be protected is important. Identifying the risks, particularly novel risks that AI might pose to them, and prioritizing across mitigations is really important and distinct work. And it's important for external stakeholders, not just people who are designing models or designing systems or even making the decisions to deploy those systems, should be doing on their own. And so another emphasis, and you can see this certainly in the M memo, which has been discussed, the federal guidance on AI, but you can also see it in the work at AC, was an emphasis on engaging affected communities both in risk identification, which can be really varied and distinct across different applications and contexts, but also in figuring out which mitigations to pursue. And this is an area where often stakeholder engagement is not something that is brought in. So I know I don't have a lot of time, and I think I kind of talked about that already. So I want to talk again just a little bit about the AI Safety Institute. And it's a start, right? It is definitely teething. It's probably going to be on life support. But as Nik and others have said, right, those technocratic aspects of how we test and evaluate and monitor and oversee AI systems are incredibly important if we want all of those high-minded principles to have any impact in the real world. And while it may be that the US AI Safety Institute does not continue to be well funded, my hope is that people who care about this being more than vaporware will continue to participate. And academics and civil society organizations have played a very strong role in everything from red team testing to establishing conferences. Sorrell was talking about the FACT conference, and standing up new philanthropic efforts and open source efforts to try to drive the development, not just of new tools and practices, but also of the rigorous scientific basis. Anybody who tells you that today we know how to test and audit these systems, you should run away from them, right? We have a set of emerging practices. I'm really not ready even to call them best, right? And we need to keep investing in this science base, which is why research is so important. I think I'll end with this one case study. One of the elements of the AI executive order was directions to the Department of Health and Human Services to issue new guidelines about bias in the healthcare system. And I think it really demonstrates the benefits of this layered approach. And because I know I'm over time, I'm not going to talk about it right now, but I just want to hold it up as an example where you can see both the emphasis on rights and the emphasis in thinking about making sure that we look, evaluate, and monitor systems so we address the systemic harms that can come from the deployment of these really powerful statistical tools. Thank you.
Is it on? Oh, thank you. Christopher, you did a lovely job of laying the table for us, and then there's been a lot of feasting ever since. So I'm turning back to you and saying, did what you hear raise a question for you that you might want to engage with?
the one that, okay, but the one that immediately strikes me is I'm not sure how much Deirdre and I disagree necessarily. I'm trying to figure out in terms of the
Is that
institute.
surprising?
Well, no, yes and no. It's sort of trying to, because it's not entirely clear. When we talk about new governance, I'm trying to figure out the modality and how that works out. And, we spoke at dinner, and the devil's in the details. This is the thing that drives us crazy, which is, the example that's often held up as a model of good multi-stakeholder governance is the IETF, because anyone can be a member. And it's very open, and on the other hand, you mentioned in dinner the CALIA process. Yeah, everyone was open, and it caused certain communities to flood it, the decision-making to go in certain
Not
directions.
IETF.
Not IETF. We were talking about ICANN is this very Byzantine multi-stakeholder process which has formal roles for everyone, which in some ways is, at least it's transparent and it's very hard to engage with, but you kind of wonder as opposed to what, which is if you don't give formal roles for different types of actors, what do you end up with? And then you have other organizations that are essentially accused or look denigrated because they're too dominated by corporations. And so what I find myself thinking is in the new governance framework, there's a lot I could agree with. And then the other, the question is how do we do with this? And in reaction to David, I'm thinking, I'm not sure that I end up in a different place. As far as I could tell, the only promising venues for actual enforcement were primarily in Europe.
In California.
And California, although the one we can talk about the ups and downs of California law. Yeah. But the interesting question then is, there's a world in which I could hear your presentation and still think that there's a major role for standard setting and private governance, not because it's ideal, but because it may be the most likely alternative for us to get something, because I think it's inevitable we'll get something out of that space. And it may be performative and distracting and all that, but maybe not. I mean, it's hard to know what we're comparing against as opposed to what.
Could I just build on this? So
That's the idea.
I started my career mostly at the Center for Democracy and Technology, and I'm probably one of the few lawyers in this room that has participated in multiple standard setting organizations and have my name on documents in them and things like that. And it is true, as a civil society organization, we had to make strategic decisions all the time, right? David, there's a lot of states. Which one are we going to go pay attention to? Are we going to spend time in Europe? Are we going to spend time in the US? Are we going to do a grassroots action? Are we going to black out the internet? We did the first one of those. What are we going to do, right? And so the fact that there are multiple standard setting organizations, and I do want to distinguish between ones that are kind of long-standing technical standard setting bodies versus things that are set up opportunistically to distract everybody, which I wouldn't go to, just saying, right? And these are different things, and civil society organizations have to make those hard choices about how they use their resources all the time, and they're pretty sophisticated. Now, in order to participate in those standard setting bodies, though, in a meaningful way, it's really helpful to have people who are advocacy technologists, as my PhD student Lauren Chambers, who's in the audience, calls them, or public interest technologists, right? People who are working in these civil society organizations who have the expertise and the credentials to participate in ways that other participants in those standard setting organizations view as legitimate. And I think it's very important to note that one of the big investments philanthropy has made in civil society spaces over the past 7 years or so is providing funding for them to have technology shops. The AFL-CIO has a tech shop. The Leadership Conference, yeah, right? The Leadership Conference has one. CDT has one, but they are proliferating not just in kind of tech and civil liberties organizations, but in a range of other civil society organizations, because technology is touching everyone. And then finally, the same way we think about the rules and procedures of different legal venues, right? I choose between regulatory processes or legislative processes. different standard setting bodies have really different rules. They may have open standards, they may have closed, pay to play standards. They may require people to disclose their patents, which is really important if you don't want to get played, right? Or to license them on reasonable, non-discriminatory terms. And so when you are thinking about where to spend your time, whether you're industry or civil society, another lens through which you need to be looking at those organizations is kind of their role in the field, right? IETF, W3C, like these are longstanding places, and when they develop specifications or standards, they tend to get adopted, right? The World Wide Web Consortium's their Web Accessibility Initiative drove the development of the standards for web accessibility that are now required under federal law, right? Like that is a good place to participate. Some of these other venues, like I wouldn't spend my time there. Their rules aren't good, their processes aren't good, they're pay to play, and you're not gonna get what you think.
Thanks. We'll go to questions in a minute. If people have questions, raise your hand. I'll get a sense of how many folks out there. Would David, do you want to jump in and say something quickly to this debate?
Yeah. Well, firstly, just Deirdre, the thing that you brought up that maybe the four tech companies wanted a new agency was novel to me because I had heard Lindsey Graham and Josh Hawley call for that publicly, the new agency, and now you're planting in my head the idea that the companies planted it in their heads.
We're always concerned about regulatory capture. Like, let's create a whole new agency for like 4 companies.
Just so we can capture it, yeah.
I don't know.
So I think that has potential. The reason I think the states are really interesting, I would also go to like Colorado or Texas or Vermont right now, or Massachusetts or New York or Connecticut. There's one organization that I know that's doing a lot in a bunch of states. It's called the Transparency Coalition. They're based in Washington State, but they've introduced a provenance bill in Washington that's very similar to the one that passed in California last year. But there's this crazy thing that I kept seeing in California happening, which is an AI bill will be introduced. There will be committee hearings that are publicly available. I'm convinced 0 people will watch the video of these hearings. The bills will get revised, completely rewritten by the tech companies themselves, and there will be a public committee analysis that no one will read, and then the bills will be destroyed by the time they get to the next committee, and no one will have noticed it, except for maybe the nonprofit that is the sponsor of the bills. But they are in a compromised position because they can't call out the horror that just took place. Otherwise, they risk losing their seat at the table altogether. And so this is why I think the states are this untapped opportunity for just anyone in this room, just actually read the different drafts and watch the video of the hearing. People depend, the tech companies depend on nobody watching that happen. So that's kind of my take. These bodies are important, yes, and I think there will be laws eventually that point to a lot of these standards, which will be important. But civil society has so little resources to go around.
Questions from the audience? Molly. You want to come take this mic? Or I can bring it to you.
Sorry. So I have 2 questions, and you can pick the one that's most interesting. And I think they're partly for Chris and Deirdre. So one is about standards. I feel like when I think sort of optimistically about beloved standards and standard-setting organizations, they tend to be interoperability standards, which I feel like have the feature that it's more important that we have a standard than that we have the right standard. And I think that seems different to me than safety standards, where it seems to matter more that we have the right standard. So I'm curious whether that makes any difference that's relevant here. And then my other question, Deirdre, you mentioned justiciability, by which I think you probably partly mean the Supreme Court's recent turn in its constitutional standing doctrine away from recognizing individual people's ability to sort of complain about systemic risk, like risks to privacy and so forth, if they can't show a concrete harm to themselves. And so I would just love to hear you expand on whether that's a really bad misfit at this very moment where we have these looming systematic risk, or whether it just means that we can't rely entirely on an individual rights framework and have to, as you say, think about both the risks and rights framework.
I guess I'm really actually channeling the presentation that started off yesterday with a very elaborate stack and the different arrows in it, which was, thanks to Catherine and Cooper. And if it were just the linear stack, it's one thing. But if with all the arrows recursively going around, this is where I get scared, Molly, which is the problem is the whole notion of near decomposition, going back to Herbert Simon, is to cabin and predefine the interactions between discrete modules in ways that we can actually create a standard and dictate the way they're going to do. And that means sort of, if you will, pre-committing and in a certain world, crippling the system to only respond to certain interactions and not to others. That diagram made me wonder, are we ready to do that yet? And so if we just have a standard to encourage interoperability, it encourages interoperability consistent with the stack envisioned by the standard. It actually retards interoperability, different innovations that depend on a different form of interoperability. And so this is what part of getting into timing. When they talk about timing, you have to start someplace. So you wait, and there's a time you put a candidate modularity or structure, standard structure in. There's such a thing as too early, but you can't wait till you know everything, because what's the point? And then you have to wait until you learn a bit more, because you have to change. But you also can't wait till you have everything perfect, because then you're also not doing anything. And so finding that sort of timing about when there's a useful time for standards to intervene is actually quite tricky. And the more, and it's quite possible that what you see is individual companies just doing their own thing. One of the problems we have, one of the issues we have is data portability, which is one of the rights mandated by the DMA, the EU's Digital Markets Act. Facebook and Google now have had data portability for years, and no one uses it. Why? Because data is configured in different ways, and unless you're going to force people to reconfigure the data to standardize certain ways, which is A, very expensive, and B, determines the functionality, we're going to may end up with worlds where we have different types of social, or different people doing different things in different ways, and that's just going to be hard to create interoperability.
So
Do you
I'm
want to
going
answer Molly's second question?
sure.
Oh,
I think Molly kind of answered her own question, but I will. The one thing I'll say, yes, I think whether it's about privacy or civil rights, we are seeing increasing threats about our abilities to enforce them, and particularly things that aren't about intent, but are about perhaps impact. And so at a time when we see courts making it more and more difficult to enforce those things that are structural and often statistical, I think the move to risk-based analysis and to requiring those risk-based testing frameworks during the development and pre-deployment and in context is incredibly important, because my belief in our ongoing ability to successfully use the court to perfect our rights is dwindling.
We have time for one or maybe two questions. Let me bring you the, sorry. Okay.
Thanks. Just quick, I was surprised not to hear about insurers in all of this. What's the role of insurers in private governance?
I'm not an insurance expert, and but the thing that leaps out at me when you say that is, my friends who do autonomous vehicles say insurance is going to change. It's huge, because you're essentially changing liability, which is traditionally assigned to an individual driver who had fairly narrow pockets and depended on an insurance industry. You're going to shift it basically to potentially a large an AV company. And then how the role of insurance in terms of risk spreading is completely different. On the other hand, the one beneficial thing you see, particularly in cyber insurance, is they actually have a tremendous interest in risk mitigation in advance. And they're one of the few actors that's strongly aligned with trying to prevent problems before they occur. And so they actually actively counsel companies in ways that is a function that I don't know if it's strictly tied to insurance, but we could do to emulate in a lot of other contexts, because the ideal thing is to avoid the problem before it comes.
Just quickly, on that, last year I tried to get a quote for SB 1047 insurance, and I couldn't get numbers. But I was told that there's a company called Beasley and Chubb that will be best positioned to be working on AI liability contracts.
Okay, last question. Anyone?
Hi. This question is for anyone, especially for David. You were talking about In case you mentioned something about openness and watch the bills and the hearings. The problem is that even in California, we have a lot of the bills that never make it to the floor to be subject to open hearings. They get killed in committees and lobbyists and everything else. And then the second thing is that a lot of times the challenges occur when private citizens take action. And by having all of these laws where there is no private right of action, we're basically creating another qualified immunity where if for some reason whoever is at the office making those decisions is somehow benefiting from the big companies or whoever it is being liable, if they could, they're not going to file any cases. So then, again, it's like a qualified immunity for.
Great. You have about 30 seconds. Let's wrap it up.
The hearings are video recorded and televised on the Senate website. So even at Senate and Assembly, so nobody knows how to find them, but if you just Google them, you'll find it. So you can watch the hearings and you can read the committee staff analysis. Those are the things that are so juicy and nobody ever finds, but you can find them. And then, private right of action, we did succeed with cited in getting one on AB 2839 about deepfakes in elections, but now X is suing to block it and it's temporarily enjoined. But the governor has shown at least one case of willingness to sign something with a private right of action about AI.
Thank you all so much for a great panel.